Is constitutional amendment a law under Article 13(2)? The question whether the word law in clause 2 of Article 13 also includes a constitutional amendment was for the first time considered by the Supreme Court in Shankari Prasad v. Union of India, AIR 1951. The court held that the word law in clause 2 did not include law made by Parliament under Article 368. The word law in Article 13 must be taken to mean rules or regulations made in exercise of ordinary legislative power and not amendments to the Constitution made in exercise of constitutional power, and, therefore, Article 13(2) did not affect amendments made under Article 368. This interpretation of Shankari Prasad's case was followed by the majority in Sajjan Singh v. State of Rajasthan, AIR 1965. But in Golaknath v. State of Punjab, AIR 1967, the Supreme Court overruled its decision in the aforesaid cases and held that the word law in Article 13(2) included every branch of law, statutory, constitutional, etc., and hence, if an amendment to the Constitution took away or abridged fundamental right of citizens, the amendment would be declared void. In Dulare Lode v. 3rd Additional District Judge, Kanpur, AIR 1984, the Supreme Court applied the doctrine of eclipse to post-constitutional law even against citizens. In that case, the respondent Land Lord filed a suit for ejectment in 1971 and obtained a decree for ejectment against the appellant tenant. By virtue of the provisions of 1972 Act, the case was transferred to the Court of the Judge Small Causes, who tried the case and passed a decree in favor of the respondent in 1973. The tenant did not object to the jurisdiction, nor did he prefer an appeal or revision against the judgment, and the same became final. The landlord filed execution petition, but his attempt to get the decree executed was stalled sometimes by objection filed by tenant and sometimes by amendments in law, and with the result that even after 13 years of litigation, the landlord was not able to get possession. This was because of the statutory amendment which made the decree inexecutable and was therefore lying dormant and ineffective. But by virtue of Amendment Act of 1976, Section 9 of the UP Civil Laws, Amendment Act of 1972 was made applicable with retrospective effect, which was enacted to remove the injustice and to remedy mischief caused to the decree holder. Its object was to revive the decrees which had become inexecutable. It was held that by virtue of the Amendment Act, 1976, the decree which was lying dormant and could not be executed became executable. Once the bar placed by the 1972 Act is removed by virtue of the doctrine of eclipse, the decree will revive and become operative and executable.